In this scenario, several California and San Francisco tenant and consumer protection laws have been violated. 1. Advertising and misrepresentation. California Business and Professions Code Section 17500 prohibits false or misleading advertising. The leasing agent's advertisement for a $1,300 unit that was purportedly available and then later claimed to be unavailable, due to being leased or uninhabitable, could be considered misleading if it was done to entice the prospective leaser to apply and pay the application fees. Violation. The advertisement for the apartment at $1,300 may be seen as a deceptive practice if the unit was never available or was misrepresented, particularly since the agent later claimed it was leased and uninhabitable. 2. Application fee and holding fee refundability. According to California Civil Code Section 1950.6, application fees are generally non-refundable unless a lease is signed, but the law prohibits charging excessive or deceptive fees. Furthermore, any deposit or fee that is charged to hold a unit must be either credited toward rent or refunded if the lease is not signed. Violation. The leasing agent stated that the application fee was non-refundable even though the unit was never actually available to lease, which could violate this law. In this case, the agent may have charged an application fee under false pretenses, knowing the unit was unavailable or uninhabitable, which is not permissible under California law. 3. Unavailability of the unit and uninhabitability. San Francisco Rent Ordinance and California Civil Code Section 1940.1 stipulates that landlords and agents must not mislead or misrepresent the condition or availability of a rental unit. In San Francisco, under the San Francisco Rent Ordinance, landlords and agents have specific obligations to disclose the condition of the property and not engage in misleading practices. Violation. The agent's claim that the unit was leased and uninhabitable only after the leaser had paid fees could be seen as a deceptive practice designed to induce payment for a unit that was never truly available or in rentable condition. Misleading a prospective tenant about the condition and availability of a unit in this way can be considered a violation of these laws. 4. Holding fees. California Civil Code Section 1950.5b. Holding fees, which are often collected to reserve a unit, must be refundable if the tenant chooses not to enter into a lease agreement. California law requires that a fee charged to hold a unit must be returned if the tenant chooses not to sign the lease. In this case, if the unit was uninhabitable and unavailable, the holding fee should be refunded. Violation. The leasing agent's refusal to refund the holding fee could be a violation of California law, particularly if the unit was unavailable for reasons beyond the prospective tenant's control. 5. Consumer protection and unfair business practices. California's unfair competition law, California Business and Professions Code Sections 17200-17210, prohibits business practices that are unfair, deceptive, or fraudulent. This law is often used to combat deceptive advertising and practices, including false claims about availability or uninhabitability. Violation. The leasing agent's actions of collecting fees for a unit that was not available, followed by a sudden claim of uninhabitability, could be seen as engaging in unfair and deceptive business practices under these sections. 6. San Francisco Rent Ordinance. The San Francisco Rent Ordinance, Chapter 37 of the San Francisco Administrative Code, provides various protections for tenants, including prohibitions against misrepresentation by landlords and agents. Landlords must be truthful about the availability and condition of rental properties. Violation. The agent's actions in stating the unit was available, taking fees, and then claiming it was unavailable or uninhabitable could violate this ordinance, which requires landlords to provide accurate information about rental units.